We'll be talking about why it is important to have a contract for all your services for the business that you're arranging to your clients or your customers. But some people still don't understand how to legally terminate this type of contract. We notice that a lot of people just leave the contract without performing their obligations or their duty, and they believe that they've successfully terminated the contract. No, because you're going to be subjecting yourself to further legal implications if you don't follow the due process of terminating the contract. So there are different ways that termination of contract can happen. The first one is termination by performance. So this is where both parties have duly completed their obligations, their duty. So the contract can be terminated by performance. Another way termination can happen is if the contract is terminated by agreement. So the both parties mutually agree that they want to terminate the contract, they don't want to go on with the contract again, and they come up with a deed of release or a termination agreement just to make sure that this contract has been terminated and they are bound by the termination. Then the other one, which is the most common kind of termination, is termination by breach of the contract. So this is where there's a fundamental breach of that contract that actually puts the party that is actually affected by such breach in a detrimental position. It can include failure to actually deliver the service or the products that has been agreed under the contract, or failure to pay the consideration, or delay in the service, or misrepresentation or fraud. This can be classified as fundamental breach of the contract and usually is always stated in the contract. So this is why it is important to also get a lawyer to look at your contract for you, to be able to advise you properly before you sign that contract. So the first thing to do, you go back to the termination clause in that contract and check how many days notice do you need to give the other party, to let the other party be aware of the breach of the contract. As soon as you've done the notice in writing according to the period of time stated in the contract, you will also give a period of time for remedying the breach, to allow the other party to make sure that the breach is remedied as soon as possible. If this breach is not remedied, then you can issue a formal termination letter. So before you terminate any contract, please consult with the lawyer that helped you to draft the contract, or consult with any legal practitioner to help you check the contract and advise you on the proper way to terminate a contract. I hope you learned one or few things in this video. Don't forget to share this video and also follow us for more.